This lecture will discuss the very question relating to the controversy raised by the ex-Vice President of India, Jagdeep Dhankar, who in an address on April 2025 expressed that Parliament to be supreme, and his very arguments and logic he cited on relying emergency of 1975 and the very judgment delivered by Supreme Court in the then important leading case ADM Jabalpur versus Sipkan Shukla in 1976 and the 38th and 39th constitutional amendments brought by the then government and the Parliament of India. Also, he made reference to the 42nd Constitutional Amendment Act of 1976 relating to the amending powers of the Parliament as provided under Article 368 of the Constitution and the powers or jurisdictions of the Supreme Court relating to judicial reviews. So, as he made his remarks on April 22, 2025, by making reference to Article 142 of the Constitution as a nuclear missile against democratic forces, as the then ex-president, Vice President of India, Jagdeep Dhankar. So in this way he made his attack on the highest judiciary of India, that is the Supreme Court. So he sought to address the very criticism he had faced and said the Constitution is for the people and its repository of safeguarding is that of elected representatives. In connection to that, he drew upon the 1975 emergency imposed by the then government led by Prime Minister of India, Mrs. Indira Gandhi, and he called it as the darkest period in human history of the democratic world, as the Supreme Court echoed the executive to hold that it is the sole arbitrator of fundamental rights which can be suspended by it. However, he then contended that there is no visualization in the Constitution of any authority above Parliament. So Dhankar's remarks had come as a response to the very landmark judgment by the Supreme Court when it set a deadline for the President and the Governor to decide on bills referred by governors of states and said that the Tamil Nadu Governor R.N. Ravi's withholding of assent over 10 bills and reserving them for the President's assent was illegal. So, Jagdeep Dhankar's remarks on April 22 came into our memory due to as he resigned the Vice President of India by sending his resignation letter to the President of India on 20th July 2025. So, the very remark of the ex-Vice President of India, Jagdeep Dhankar, included contradictory statements as it ignores the constitutional scheme itself, which holds that the constitution is supreme and the parliament itself is its creation and not otherwise. And in his remarks, speaking at the Delhi University, Danka criticized the Supreme Court by drawing attention to the emergency of 1975. As he said, Supreme Court had ignored the very verdicts of 9 high courts then that had held that fundamental rights cannot be put on hold. As 9 high court verdicts were uniform that in democracy fundamental rights can never be put on hold. Access to judiciary cannot be moderated, much less denied, being a fundamental right under Article 32 of the Constitution, as it was expressed by the ex-Vice President of India, Jagdeep Dhankar. But was that done? What was held by the Supreme Court? The executive of that day is the sole arbitrator of fundamental rights and it can suspend them for as much time as it likes. There was one dissent voice, the dissent, and that emanated from an almost from this place, as he addressed to the students of Delhi University on April 22, 2025. In that address, he made reference to the 1976 ADM Jabalpur versus Srikant Shukla case, in which the Supreme Court by a 4-1 majority set aside 9 High Court judgments which had ruled in favor of enforcement of fundamental rights during the emergency. Only Justice H.R. Khanna, the sole dissenter, was the uncle of the previous Chief Justice of India, Justice Sanjeev Khanna, as made reference by the then Vice President of India. So while in criticizing of the Supreme Court in the case, he went on to contend that Parliament is supreme and that the Prime Minister who had imposed emergency was held accountable after elections in 1977, as because the then late Prime Minister Mrs. Indira Gandhi lost the elections in 1977. So too, in his words, a Prime Minister who imposed emergency was held accountable in 1977, and therefore let there be no doubt about it. The Constitution is for the people and its repository of safeguarding is that of elected representatives, and that is the Parliament. Further, he added that the parliamentarians or the people's elected representatives are the ultimate masters as to what constitutional content will be. There is no visualization in the Constitution of any authority above Parliament. Parliament is supreme, and that brings the situation, let me tell you, as he addressed, it is as supreme as every individual in the country. As he expressed, the part of the Constitution that we the people is an atom in democracy, and that atom has atomic power, and that atomic power is reflected during elections, and that is why we are in a democratic nations. Further criticizing emergency and holding Parliament to be supreme, the ex-Vice President of India, Jagdeep Dhankar, did not, however, make any mention of the excesses by Parliament itself during the period that defined the emergency. The Parliament had passed a slew of amendments to Constitution that stripped judicial powers and concentrated in the hands of Parliament, such as the Constitutional 38th Amendment Act that barred judicial review of the emergency, and the Constitutional 39th Amendment Act, which took away the power of the Supreme Court to try electoral disputes concerning the President, Vice President, the Speaker of the Lok Sabha, has vested this power in a separate body and gave immunity to the Prime Minister from electoral laws in a bid to nullify the Allahabad High Court's judgment delivered in the important leading case, that is Raj Narayan versus Indira Gandhi, where the other had struck down Mrs. Gandhi's election on the grounds of electoral impractice. Further, the Constitution 42nd Amendment Act 1976, as cited by the ex-Vice President of India, Jagdeep Dhankar, another excess during the period inserted the words sovereign, secular, socialist, democratic republic in the preamble, but also stripped the judiciary of its right to hear election petitions, gave wide-ranging powers to Parliament to amend the Constitution, which would remain outside the ambit of judicial review. It also provided that any law passed by Parliament to implement directive principles should not be subject to judicial review. So now the very question that raised in everyone's mind, that whether the Parliament is supreme or the Constitution is supreme. So in that connection, we will discuss about the very judgment delivered in the important leading case Kesavananda Bharati versus State of Kerala in 1972, where the apex court framed the very doctrine, that is the Basic Structure Doctrine, and the amending powers and limiting the amending powers as provided under Article 368 and for the establishment of rule of law, then separation of powers, and the very independence of judiciary. So, Parliament is under the Constitution of India, because as we analyze the very parliamentary system adopted in United Kingdom and the parliamentary system, even though borrowed from United Kingdom by the Indian Constitution, is having some limitations. So the very supremacy of Parliament and the constitutional supremacy in India and the fundamental rights that we would like to discuss. So while the ex-Vice President of India has sought to pit one organ of the government against the other, according to constitutional experts, the Constitution itself is supreme. The Parliament, the Executive, and the Judiciary, all creations of the Constitution, and therefore none of these institutions are supreme. It is only the Constitution that is supreme. And this has been clarified by various Supreme Court judgments, and it is a settled position in Indian legal and constitutional history. For instance, Parliament can amend many things, but not the basic structure of the Constitution, and that is the limitation imposed on the parliament by the judiciary, because the judiciary's job is to interpret and protect the constitution. So in the 1973 Keshavananda Bharati judgment, which upheld the basic structure doctrine and placed limits on the power of the parliament to amend the constitution. A 13-judge bench constitution ruled 6/7 to hold that the Constitution of India has a basic structure that cannot be altered even by a constitutional amendment. The court held that Parliament's amending power under Article 368 is not unlimited and that it cannot alter the basic structure of the Constitution, including the principles of the rule of law, separation of powers, and the independence of judiciary. The court held that while there is no rigid separation of powers in the Constitution of India, the Constitution itself creates a system of checks and balances by distributing powers and division of powers between the three organs of government, so that one cannot become predominant over others, as it was observed by the apex court in their novel words. We are unable to see how the power of judicial review makes the judiciary supreme in any sense of the word. This power is of paramount importance in a federal constitution, as we could examine the federal constitution of the United States of America, where exactly judicial review innovated in though that important leading case, Marbury versus Madison in 1803. Indeed, it has been said that the heart and core of democracy lies in the judicial process. So, Parliament is under Constitution, not over it. As we here refer, a remark and a statement made by an constitutional law expert and the Vice Chancellor of the Chanakya Law University, Dr. Professor Faijan Mustafa, who expressed that unlike the British Constitution, the primacy of Parliament has not been adopted in India, as according to his expression, the framers of the Indian Constitution have not adopted the supremacy of the parliamentary doctrine, as we found in England or in the United Kingdom, in spite of borrowing the very parliamentary feature from the British parliamentary system. Indian Parliament is under the Constitution. It is not over or above the Constitution, as the Indian Parliament is a creation of the Constitution. It is like any other authority subordinate to the Constitution. So the very supremacy of the Constitution that we found from the very critical analysis of the Constitution of India and not the Parliament of India. So to maintain the very supremacy of the Constitution, the constitutional design adopted by our fathers of the Constitution or constitutional makers in the Constitution, Constituent Assembly, as that the Parliament can pass a law, but the constitutionality of what law can be challenged in constitutional courts. and in particularly in case of Indian Constitution, the high courts of different states as under Article 226 and the Supreme Court of India as under Article 32, Article 136 and Article 142 of the Constitution of India. That law can be challenged the constitutional courts. And if the law or any provisions of that law which was or is enacted either by the parliament or the legislative assemblies to be in contravention of the constitutional provisions or fundamental rights of the citizens as guaranteed under Part 3 of the Constitution of India. The constitutional courts here, exactly the Supreme Court or the highest court of the country, and the high courts in different states would be well within their jurisdiction as provided under the Constitution under Article 32, 136, 131 and 142 or Article 226 in relating to high courts jurisdiction to strike down that provisions made under a law either enacted by any legislative assembly or by the Parliament of India as unconstitutional if that particular provision violates the very constitutional spirits, the basic structure of the Constitution, or the fundamental rights of the citizens guaranteed under Part 3 of the Constitution under Article 13 to Article 35 of the Constitution of India. So, Professor Fajan Mustafa expressed that power of judicial review as provided under Article 32 of Indian Constitution is an integral part of the supremacy of the Constitution as the Constituent Assembly representing the very will of Indian people has given this power to the apex court as because the very wording of the preamble expressed that we the people of India, because you can't be challenging the decisions of parliament in the parliament, you cannot be challenging the very decision of parliament in the executive, which commands the majority. All the bills passed in parliament are piloted by the government itself, and that is the executive, and that is the council of ministers in case of either the union government or state government. Therefore, there was no option but to give this responsibility to an independent organ of the Constitution, and that is the judiciary. The very duty of that independent organ or the judiciary is to ensure the supremacy of the Constitution. The constitutional scheme, while not explicitly including separation of powers, as we found a strict separation of powers in the American Constitution, still includes a system of checks and balances and separation of functions by division of power among the three organs of the state, then distribution of administrative, financial, and legislative powers between the union and among the states under a federal scheme. Therefore, a law passed by Parliament can be struck down by the courts. Judges can be impeached by Parliament as it is also provided, and at present scenario, a presiding judge of the Allahabad High Court, Justice Jaswant Verma, when he was a judge of the Delhi High Court, is under a motion of impeachment in the Parliament. President is elected also by the elected representatives, where the elected members of state assemblies and also the elected members of the parliament, they participate in its elections. So also the president can be impeached by the parliament. Even a no confidence motion can be brought in either in the House of People or in the legislative assemblies to remove a council of ministers. So the constitutional design is constitutionalism, which is limited governance. Even though the Supreme Court is not supreme, they also cannot go beyond the powers given to them by the Constitution as provided in the Constitution itself in the form of original jurisdiction, appellate jurisdiction, and also relating to in particularly civil and criminal appeal jurisdictions. Then finally the jurisdiction relating to advisory role as provided under Article 143 of the Constitution, of which recently the present President of India, Mrs. Draupadi Murmu, referred to the apex court or the Supreme Court in relation to the judgment delivered by a single bench of the apex court relating to the governor of Tamil Nadu giving his assent, not by giving his assent to the bills enacted by the Tamil Nadu Legislative Assembly, where the single bench decision of the Supreme Court expressed that there is the time limit of 3 months. The President and Governor is bound to give his assent to such bills enacted either by the legislative assemblies of the state or by the Parliament of India. So at present the very reference made by the President of India under Article 143 of the Constitution to the Supreme Court, which would be decided by a constitutional bench, by presiding the Chief Justice of India. In the last coming week of July 2025, so from the very analyzing whether Parliament to be supreme and whether the Constitution is supreme or the Union Judiciary or the apex court, the Supreme Court of Judiciary, we have analyzed and critically assessed the very expressed views by the ex-Vice President of India, Jagdeep Dhankar, who resigned on 20th July 2025, but the very address he made on April 22, 2025 to the students of Delhi University. Then we have analyzed the opinions expressed by Professor Dr. Faizan Mustafa, the Vice Chancellor of Chanakya Law University. And finally, we come to the conclusion that the Constitution of India is supreme, not the Parliament, not the Union Judiciary, not the Union Executive. So ultimately, for concluding sentence would be that from the very structure and analysis of the Constitution of India, it could be drawn finally that the very preamble of India itself pronounced with the people of India shows the Constitution of India is supreme in the land, not the Parliament, not the Union Executive, not the Union Judiciary.